Welcome to Vinnie Politan Investigates. I'm Jenaé, filling in for Vinnie tonight. Our investigation is focused on a woman named Karen Reed. Her trial is in Didnt, Massachusetts, and it's divided the community there and people across the country. Here's her story. Karen Reed was a college professor dating a Boston police officer named John O'Keefe. Outside of her family, friends, and students, no one really knew much about her. But that anonymity changed one snowy night in Canton, Massachusetts. After she and John went bar hopping downtown, Karen drove them to the home of another Boston police officer. He had invited a bunch of folks over his house for a little after-hours party before the blizzard was supposed to roll through town. John O'Keefe died that night, and everyone agrees it was a homicide. But the question is, who is responsible? And the answer depends upon who you ask. The prosecution says John never made it inside that home because Karen purposely backed over him and left him lying in the cold in the front yard to die. Karen says John went inside to the party and she went back to John's house. She also believes it was someone from inside that house who killed John and put him in the yard to frame her. After more than 9 weeks, more than 70 witnesses, and nearly 5 days of deliberations, the jury could not reach a unanimous verdict and a mistrial was declared. Karen Reed will have to do it all again, but what will a new jury make of the evidence at trial number 2? And here's what the prosecution says. Karen Reed drove herself and her boyfriend, John O'Keefe, over to the Alberts house that night. And when John got out of the SUV, she purposely backed into him and left him at the scene. But around the same time that Karen and John arrived at the Alberts house, Ryan Nagel and 2 friends were pulling up in a pickup truck. And Ryan's sister was at that party. She needed a ride home. Now, according to Ryan Nagel's testimony, the pickup truck was behind Karen's vehicle the entire time it was in front of the house. And no one in that car reported seeing John O'Keefe walk into the house or being struck by Karen's vehicle.
As far as the black SUV in front of you, what, if anything, did you observe about movement of that vehicle at any point?
I noticed that the brake lights, the only reason I noticed is because the brake lights were on and it moved, I would say moved up maybe another car length in front of us.
After you turned from Cedar Crest on the Fairview, that vehicle was in front of you the entire time?
Oh, yes, sir, yes.
As far as around the vehicle, at any point in time, did you observe anybody exit the vehicle or be outside of the vehicle or anything like that?
No, sir, no, I did not.
And did you see anybody go from the vehicle to the house?
No, sir.
What, if anything, did Ricky do with the truck?
He pulled out to go around the SUV in front of us and then to go home. I observed that there was a person inside the car with the interior light on.
And that would be sort of a dome light, is that right?
Correct, sir, yes.
Can you see where the dome light was, as far as in the left, right, or center of the vehicle?
I was in the center.
And can you describe the person that you saw? Where were they? First of all, where were they in the car?
They were in the driver's seat.
And can you describe what the person looked like?
It was a woman.
And how do you know that it was a woman?
Had long hair. Seemed like she was looking straight ahead with her hands at 10 and 2 on the steering wheel.
You didn't see a person standing or lying on the ground anywhere around that SUV, did you?
No.
But you did look inside that SUV.
As I passed by, yes.
And you saw one person?
That's all I saw at the time, yes.
Female with long hair, is that
correct?
Right? And you did not see anybody else inside that SUV?
No, not to my acknowledgement.
So what we're digging into is if Ryan Nagel had a clear view of Karen's SUV from the time it pulled up to the house and didn't see anyone get out of the vehicle, how could Karen Reed be alone in the vehicle when Ryan Nagel and his friends left? So that brings us to our first big question of the night. Did Karen hit Officer John O'Keefe with her car? So we want to bring in our guests. We have 2 people who can tell you both sides of the arguments in this case. Karen Reed supporter and creator of the Justice for Officer John O'Keefe and Karen Reed Facebook page, Nick Rocco, is with us. We also have the creator behind Yellow Cottage Tales YouTube channel, Kevin Lenahan, is with us as well. Great to have you both on to talk about this case. Nick, let me start with you. What does this witness testimony tell you about whether or not Karen Reed hit John O'Keefe with her vehicle?
So I think Ryan Nagel stating the fact that Karen Reed was alone in her car when they drove by putting John O'Keefe not on the lawn, not inside the car. There was only one place that he was headed, and that was 34 Fairview Road. So when he got out of Karen's vehicle, he didn't go for a jog or a run down the street. He went inside the house. Now, Ryan Nagel is, he's from Canton. He knows all those players. So for him to get on the stand and put John not in that vehicle, I'm not sure where else he could have been, because he wasn't on the lawn. Karen didn't back up at that point, like they're saying. So where else could he be? I mean, it's at this point, I think that question, if he's not there, there's only one other place he could be, and it's inside the house.
Which is what Karen Reed's defense has argued in this case. Kevin Linehan, how do you see this testimony from Ryan Nagel?
Well, it's hard to focus on. I think it's a mistake to focus on things that we don't see or that someone doesn't see. You can only focus on things that they do see. It's hard to explain why someone doesn't see something. So one thing that came out in trial was that the plow driver, Lucky Laughran, plowed the street at 5:30. That's only a half hour before John was found. And he, despite plowing the street and all the lights that he had up there, didn't see John there either. So, I mean, what Ryan Nagel was doing when he pulled up, he's looking at his phone, he's talking to his girlfriend in the back seat. We don't know exactly what he's doing, but he's not paying attention to this lawn, and there's no street light there at the end of the property, so it's very, very dark. We do know that that what he did see was that the interior light was on, so John was probably in some process of getting out or having just got out. And just, it's important to keep in mind that the GPS, which could not be challenged by the defense, because there's no way to challenge that kind of data, shows that John did not go inside the house. He was never even seen, according to that GPS, heading in the direction of the house. He was found at the edge of the last GPS points are at the end of the property, at the far edge, where Karen left him off, and that's where he was found. So unless John dropped his phone there and went inside the house, the more likely thing is that people just didn't see him.
Nick, what do you think is the strongest evidence that John O'Keefe was actually inside of the house?
So during Brian Higgins' testimony, he actually places a tall male with dark hair inside the house, never named them. He knew who they all were, so it wouldn't have been a surprise if, for example, if it was Colin or Brian Albert Jr., he would know who they were. Yes, he did know John, but I think he specifically didn't name John O'Keefe, because if he puts John in the house, he's kind of turning on the whole everybody inside the house. He didn't go in. If he doesn't put John in the house, now he's lying to the feds, and he knows the penalty of that. But other than that, you have the Waze data with the timing being off. His phone shows John going up the 3 flights of stairs. So as far as him being inside the house, he wasn't on the lawn. Nobody saw him out there. And I know Kevin says it's not what people don't see, but it's very hard to miss, especially when Brian Higgins, supposedly is parked out front. He turns his car lights on. You're not going to miss John O'Keefe on that lawn when there's an inch, not even an inch of snow at that point. You just physically could not see it. Even if you weren't looking for him, you still would see something there.
We're going to take a look at that more next. We are. And I know that Kevin has something he wants to show us in that regard, but let me focus back to the snowy night, the snow plow. Do you think the conditions, Kevin, if you're the prosecution, had anything to do with the lack of people being able to see? Because this was a blizzard everyone was waiting for, but there seemed to be conflicting accounts about whether the blizzard had started, whether it was heavy, whether it was just flurries.
I don't think it was snowing very hard at the time when the guests were leaving the house or when the pickup truck with Ryan Nagel in it was driving by. What I think is if you go out and get in your car now and drive to the supermarket or whatever, a couple blocks away and come home, there's going to be 10,000 objects inside yards that are dark and unmoving, and your mind is not going to pay attention to them. That's just the way it's peripheral vision, and unless something signals your conscious mind, flags it and says, "Here's something interesting here," you're not going to make any note of it. So if John had been moving, then would have been more likely for people to notice him. But otherwise, he's just a dark, unmoving object that the conscious mind isn't really going to pick up as they're driving by.
We have so much more to talk about in this case that still has lingering questions. Our guests are going to stay with us. Coming up next, there were a lot of people going in and out of that house. Why didn't anyone see John O'Keefe on the lawn?
When you got in that SUV of yours, you didn't see anything out of the ordinary outside, correct?
I wasn't looking outside.
Okay. I know that that is the answer that you want to give to every question. My question is yes or no. Did you see anything out of the ordinary?
No.
In the world of true crime, the path from victim to verdict is never a straight line. Join me for a Court TV original series that takes you through every dark twist and turn, from the crime scene to the courtroom, in America's most compelling cases.
She killed my daughter, and he marries her.
Victim to Verdict with Ted Rollins, a Court TV original series. New season premieres September 8th.
Only on Court TV.
When you went over to the storm door and looked out, what if anything did you see?
I saw a vehicle.
Can you describe the vehicle that you saw?
I saw a dark SUV.
I noticed the big SUV parked in front of the house.
So when I noticed, looking out the window, I did notice the SUV in front of the mailbox, and then pulled up a little bit in front of the yard, and then stopped, and then pulled up again towards the flagpole.
There were multiple party guests who were inside of the Albert home at this party looking out the window. They reported seeing Karen Reed's SUV pull up in front of that house that night. Prosecutors say that it's within minutes of that arrival that John O'Keefe exited the car and was struck by Karen's vehicle traveling in the reverse. And if that's the way it happened, John O'Keefe would have been lying outside in the front lawn when that party was over and the guests found their way out of the house and to their own cars.
At no time did you hear any noise or sound outside that was unusual?
No.
You didn't hear any squealing of tires or squealing of brakes?
No.
You didn't hear any screaming or yelling?
No.
You didn't hear any loud voices or foul language or doors slammed?
No.
You didn't hear any verbal argument or the revving of an engine, anything like that?
No.
Matter of fact, you didn't hear any collision or crash, did you?
No.
You left the location at about 1:45, is that right?
Yes.
You didn't see anything out of the ordinary as you got in. Was it your car or Mr. McCabe's car?
It was my car.
When you got in that SUV of yours, you didn't see anything out of the ordinary outside, correct?
I wasn't looking outside.
Okay. I know that that is the answer that you want to give to every question. My question is yes or no. Did you see anything out of the ordinary?
No.
After being at the Albert home for a period of time early that morning, you left the home approximately 1:40 a.m. or so?
Yeah, give or take 1:40, 1:45. I don't know the exact time.
And you walked out with your wife, Jennifer McCabe, and two of Brian Jr.'s friends, correct?
Yes, Brian's two friends were joining Jennifer and I. We were driving them home.
And when you first came out of the house facing that front lawn, you didn't see a black baseball cap, correct?
That's correct.
Or a black sneaker, correct?
That's correct.
Or 45 pieces of red plastic taillight, correct?
That's correct.
Or even one, correct?
That's correct.
And once again, you didn't see a 6'2" man lying on the front lawn, correct?
No, I wish I did, but I didn't.
Coming out the front door of your house, you would agree with me that your parents' front lawn is directly in front of you, correct?
Yes.
By that time, snow had started to accumulate at 1:45 a.m., correct?
Yes.
Against that white snow, did you see a black baseball cap?
I did not.
As you stepped out of the house, did you see a black sneaker?
I did not.
Did you see 45 pieces of red taillight plastic?
I did not.
No. Did you see one piece of red taillight plastic?
I did not.
Did you see a 6'2" man on your parents' front lawn in front of you?
Objection.
Did you? I did not.
Some of the most important evidence in a case is eyewitness testimony. We don't have that here, but the next best thing to an eyewitness testimony is a before and after witness, and that's what these are. But that brings us to our next question. Why didn't anyone see John O'Keefe on the lawn? Still with us, Nick Rocco and Kevin Lenahan. Nick, I messed up a little bit earlier. You're the one that has something that you want to show us having to do with people going in and out of the house, in particular, someone else who took the stand.
Yeah, so Brian Higgins, the Commonwealth is trying very hard to place his vehicle in between Ryan Nagel's vehicle and Karen Reed's vehicle. Now, let's just say that his vehicle was there. And this video almost goes to anybody that would drive down that street. And what it is, it's a recreation from Microdots, and it's Brian Higgins' vehicle parked right outside the mailbox. He turns his lights on, he's getting ready to drive away, and what do you see? His lights are right on the flagpole, and John being so close to the street, there's almost no way to miss it. Whether you're looking for it or not, when there's about an inch of snow on the ground, everything is white except a 6-foot body. You just can't miss it. So the only person that stated they saw something was Julie Nagel, and she placed a black blob on the lawn. Now, it wasn't like the next day when they found John O'Keefe's body, she was like, oh my God, that's what I saw on the lawn last night. That's what I remember. No, it took her 8 months to get interviewed by Michael Proctor to finally say, you know, I saw something on the lawn, a black object. And then a year later during court, she remembered it was 5 to 6 feet long. Nobody saw John O'Keefe on the lawn because he was not out there when Karen Reed had left to go back to John's because she didn't back into him. He was inside the house. And then later on that night, early morning, somebody had placed him outside. I mean, if he wasn't there and nobody saw him, where could he have been?
And we're going to get to more of what Julie said, because that is an important thing to look back at. But Kevin, first, I want to get your reaction to the question. Why didn't anyone see John O'Keefe on the lawn? They were going out, not just one person, multiple people going back to their cars, and no one seeing a body, a shoe, a hat?
Well, I can react a little bit to that video first. It's obviously fictional, and I don't think most people park in a yard would expect that their lights to illuminate the yard if you're parked on the street. And we don't know exactly what direction it is, but the lights are designed to illuminate the road in front of you. And we also know from Brian Higgins' testimony that when he began to drive off, his plow was in too low of a position, and as he drove, he had to adjust it. So his eye was looking down at something else. But again, we're trying to focus on what people didn't see, a dark, unmoving object, when what we have in terms of the correlation of the vehicle data, which was not challenged by the defense, and the data on John's phone perfectly shows, just like a video or a picture, that there's no way that Karen didn't do this. So Karen they were following Waze to get to 34 Fairview. She missed the turn onto Fairview. That's recorded by Waze. A little bit after that, she does a 3-point turn, like say 10, 15 seconds after that, to adjust. And you can see that in the vehicle data. Then she finally takes the turn onto Fairview, which is recorded in Waze. 8 minutes and 4 seconds after that 3-point turn that she did on Cedar Crest before that, 8 minutes and 4 seconds after that puts it at 12:32 and say 9 seconds. And the health app on John's phone shows that he stopped moving for the last time until 6 o'clock in the morning when somebody picked up his phone. He stopped moving at 12:32 and 16 seconds. The correlation is bulletproof. You can't punch a hole in it. It's better than a picture. There's no way around it. You just have to present this to a jury properly.
And this is why it was so difficult for a jury, because two sides arguing the same thing about the evidence. I want to talk more about this one person who said she saw something. Matthew and Jennifer McCabe, they agreed to take Sarah Levinson and Julie Nagel home after the party. And Julie took the stand to testify that she did see something unusual on the lawn. Let's take a listen.
I did notice behind Sarah and Jen, I did notice something out of the ordinary, like a black blob in the ground by the flagpole.
So Nick just talked about this. Julie Nagel also testified that after she saw the black blob on the lawn, that she mentioned it to the others in the car, but no one else in the car remembered her making that statement. But Nick, I want to bring up something that Kevin said. The snowplower didn't see anything out in that area in the lawn as well. So is it possible that he didn't see it? She could have seen something even if he didn't.
Well, Julie Nagel's testimony, I think at this point, being interviewed 8 months later by Michael Proctor, I don't think she has much credibility, just for the fact that her story got, I don't want to say better, but it evolved to fit the prosecution from the first time she interviewed to the last time she interviewed, it just got more detailed. So, like I said, if she saw something on the lawn after they were done talking about the peanut butter and jelly sandwiches in the car, I think the next day when John was found, the first thing anybody would have been like is like, that's what I saw on the lawn. They would have went right down to the police department, and it could have been, here's the first eyewitness. But instead, it took way too long for that to come out 8 months later, 2 years later during the trial. So I don't think what she's saying is credible. I think they needed to have at least one person see something, because how do you just not have 13, 14, and whoever else drove down the down the road that early morning, aside from the plow driver and the person who parked the Ford Edge exactly where John's body was? Nobody saw the body to call 911. It's almost impossible.
Kevin, real quick before we have to go to a break, we talked about the conditions. You said it wouldn't have been that bad at 12:30, but now we're talking about an hour later. Do you think that had anything to do with it, or the festivities that were going on inside of this party where alcohol was present?
I just think your peripheral vision doesn't pick up stuff like that. And let's also just apply some quick logic here. So let's say that the defense theory is true, that the 4 people in the car knew that John was lying there, dead or dying. I'm sorry, the defense theory is they put him out later, right? So I just, I apologize. The theory is they put him out later. And I just don't think, I think he was there and people didn't see him. I mean, that's the most sensible thing.
Kevin,
when you look at the rest
thank you so much for your comments. Nick as well, thanks for being with us. We do have to get to our break. I'm Julie Jenaé. In for Vinnie Politan, we'll keep digging for answers as the investigation continues. Welcome to Vinnie Politan Investigates. I'm Julia Jenaé, filling in for Vinnie tonight. Our investigation focuses on the death of a Boston police officer, John O'Keefe, and the woman the prosecutors say is responsible is his girlfriend, Karen Reed. Here's her story. Boston police officer John O'Keefe was found dead on a fellow police officer's front lawn in January of 2022. Prosecutors say after a night of bar hopping, John's girlfriend, Karen Reed, dropped him at a house for an after party before purposely backing her SUV into him and leaving him to die in the snow. But Karen Reed says John did go into that house party, and inside, John was killed and left outside to frame her for the death. Karen Reed's case drew national attention at trial. The jury couldn't make a decision. A mistrial was declared, and now Karen will have to do it all again for trial number 2. Going forward, will either side change their strategy? The defense in this case filed a motion to dismiss 2 of the 3 charges against Karen Reed after a mistrial was declared in her case. The defense argued that jurors from this case came forward after that decision, and they revealed that they had, in fact, behind closed doors, reached a unanimous verdict of not guilty on the charges of second-degree murder and leaving the scene of an injury or a death. The judge heard oral arguments for the defense's motion to dismiss in the months that followed the trial.
When we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty, we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not.
Now, the judge in this case, Judge Beverly Cannoni, ultimately denied the defense's motion to dismiss those 2 charges. But if the jurors agreed that Karen Reed was not guilty of 2 of the 3 charges against her, here's our question. Did the jury believe that Karen Reed hit John O'Keefe with the car? Let's bring in our guests for this segment. Criminal defense attorney Joseph Kowsky Jr. and trial attorney and partner at Brown Rudnick LLP, Wayne Dennison, is with us. Thank you both for being here. Let's first talk about the reaction from these jurors. Wayne, let me start with you. The jurors coming forward, the judge said she was going to accept her motion as accurate. But what do you think that says, if those statements are accurate, about what those jurors in the jury room believed about the impact and if it happened?
Well, I think if the statements are accurate, it's quite clear that they didn't think that Karen Reed intentionally killed John O'Connor, and that issue, which I think was overcharged to begin with, is probably off the table. From the reports that we can thus far glean, what we know is that we've got some jurors who apparently were split on the possibility that she hit him with a car. I think that that's the only thing I could glean from those reports.
Yeah, those reports were really important. The judge did not bring in any jurors into the courtroom to talk to them directly, but she did say for purposes of making that order that she would accept what everyone was saying about these juror statements. Robert, let me ask you if you think, based on what we've heard about the split and what jurors were saying inside of that jury room, if they believe that she actually did hit him with the car, even if they couldn't agree on that middle count of manslaughter.
You mean me, Joe? You forgot about me already. It's been a couple of weeks.
Apologize.
Just good. So look, the import of the information, for the sake of argument, it's true, would mean that the first charge was charged with murder. If they believe that Karen Reed was not guilty of that charge, the showing of murder in Massachusetts requires proof that she intentionally did an act or she intentionally struck him. It's malice. They also believe that she was not guilty. If, for the sake of argument, you believe the accuracy of the information and reliability of the information being reported, they believe that she was not guilty of leaving the scene after causing personal injury. That also has a knowledge element to it. Conversely, what's going to be a little unnerving for her defense team is that same information was reporting either 8-4 or 9-3 or as high as 10-2 guilty on the manslaughter charge. And the difference between the manslaughter charge and the murder charge is that there's no requirement that she intentionally struck John O'Keefe and no requirement that she knew she hit John O'Keefe. The mere fact that she was drinking while intoxicated and put in motion the events, here in this case, her car striking John O'Keefe, causing his death, is enough. So, that's the converse side about this, and it's probably causing some alarm in the Karen Reed camp.
Yeah, Joseph, to your point, there were so many different splits that came out of this so-called reporting about what the jury decided on, that it was 6-6 for manslaughter, it was 8-4, 10-2, and it's hard to know what they really were arguing about in terms of manslaughter. But I want to show you this. This was from one of those filings. According to the defense, there was a juror who came forward and made this statement, and they were calling that juror B. That juror B confirmed that he or she had texted, quote, "It was not guilty on second degree," and split in half for the second charge, meaning manslaughter. And it goes on to say no one thought she hit him on purpose or even knew that she had hit him. Wayne, your reaction to a juror going so far as to clarify that nobody in the room thought that it was done on purpose?
Well, that does explain the outcome here, at least as it's been recounted to us, because as Joseph just talked to you about, both of the other charges required intent. And you can accept that she didn't do it on purpose. You can accept that she might not even know she'd done that, but still get to the second charge of manslaughter.
Well, I want to talk about this as well. We now know that the family of John O'Keefe, they filed this civil complaint for wrongful death against not only Karen Reed, but also the bars that served Reed on the night that John O'Keefe died, so a dram shop allegation. The complaint alleges that the bar's owners shared responsibility with Reed for O'Keefe's death. And in addition to this allegation, the lawsuit includes claims of negligent and reckless infliction of emotional distress against different members of John O'Keefe's family because of the loss of him. And they're naming the owners of C.F. McCarthy's, Waterfall Bar and Grill, names that we heard during this trial. Joseph, it's interesting the timing of this civil case. They did wait until the first trial was over, but do you think this is a time period where they can be successful in bringing it now when we haven't gotten to an actual trial that has an outcome?
Well, I do, because the civil standard is less. It's a preponderance of the evidence. It's not proof beyond a reasonable doubt. I happen to read the complaint. They filed it in the Brockton Superior Courthouse right out in front of my office today. And the difference is certainly there's a lesser standard. Strategically, I think it was very smart. They have the benefit of the first trial. They have the benefit of understanding the defense strategies. They have the benefit of witness testimony that's been memorialized and preserved on transcript. So I think they have a much better understanding of the liability issues than you would have in a typical civil case. The interesting thing is now the discovery is going to start, and how Karen Reed's going to try to mount a defense to a criminal case while simultaneously defending her case herself civilly. Obviously, she still has Fifth Amendment protections even in a civil case. What I think they'll do is move to stay the civil case pending resolution of the now pending still pending criminal case.
And Wayne, asking you as well about this civil lawsuit. If it goes to a trial, we've still got a county that seems divided when it comes to Karen Reed. Do you think we may see a different outcome if it comes to a jury trial? We know most civil trials end with a settlement.
Well, but a civil trial in Massachusetts, like that trial, is not going to get heard for 3 years at minimum. The criminal trial will have likely resolved long before that, unless you get another mistrial, I guess. So I agree with Joseph. I think the likely outcome here is that the case is going to be stayed until the criminal trial goes forward. The criminal trial will long be over. The evidence adduced in the criminal trial will again, as Joseph suggested, be available for both the plaintiffs and the defendants, because there are certainly testimony that the defendants are going to want to rely on that has thus far been provided. And you can only get an outcome, easily get an outcome, largely because of the different standard of proof. It's not beyond a reasonable doubt. It's preponderance of the evidence, 51%.
Absolutely. Two cases going on now at the same time as we move forward. Wayne Dennison and Joseph Kowsky Jr. stand by. We have more to come. Is either side going to change their strategy? We're talking about that second trial. Are they going to do anything different the second time around?
No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
The most successful true crime TV shows ever.
This is crazy.
Now has a new home on America's original true crime obsession, 48 Hours on Court TV. Coming up next on Court TV.
It's the biggest story that we're covering.
He is the boogeyman.
Lori Daybell.
She said, I will have you destroyed.
She's got another murder trial coming up.
A social media sensation, now a suspected killer.
Karen Reed was framed.
So the only response that I was personally given was just, I hit him. Oh my God, I hit him.
I did notice something out of the ordinary, like a black blob in the ground by the flagpole.
That morning, I don't remember specifically what I Googled, but I do know what you've put out to the social media.
How about this? Hoss longed to die in cold. Does that sound familiar? Was the whole point of that trip, Miss McCabe, to search for John?
It was, because she knew where he was.
And yesterday, during the entirety of your questioning by Mr. Lally, not once did you mention that this video is actually completely inverted.
I did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected.
Yep, so these came from me. From all accounts, he didn't do anything wrong. She's a whack job.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
You weren't so much as objectively investigating her as objectifying her in those moments, correct?
Again, Mr. Jackson, it was a poor choice of words and a joke.
Did the warrant say anything about looking for news of my client?
Objection.
Did it say anything about that?
No, Your Honor.
Okay, next question.
So that would be an abuse of the power that was given to you by the court, correct?
Objection.
Sustained.
Those were some of the big moments from Karen Reed's first trial, where the prosecution laid out their case saying that she hit him. She hit John OKeefe, her boyfriend, with her SUV and left him to die in the snow. And the defense said that Karen Reed was framed by a group of Canton police officers, other officials, and neighbors who they said killed John OKeefe. The trial was long and the evidence was complicated, but after deliberating for 5 days, the jury sent this note to the judge.
Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
Now, because Karen Reed's first trial ended in a mistrial, Reed, her defense, the prosecution, all these witnesses, they have to do it all over again. January 2025 is when it's slated for. And that brings us to our last question of the day. Will either side, with everything they know, change their strategy at the second trial? Let's bring back in our attorneys who understand Massachusetts prosecutions better than anyone. Joseph Kowsky Jr. and Wayne Dennison are with us. Joseph Kowsky Jr., let me start with you. Do you think the state is going to do anything different? Who should they perhaps not call or call differently in this second trial?
My criticism of the prosecution of this case is they spent too much time chasing the defense strategy, chasing the third-party culprit strategy on the presentation of their case. Charge the case the way they think it should be charged and present enough evidence you believe that you need necessary of the elements beyond a reasonable doubt. By getting into all of these witnesses and trying to preempt the third-party culprit, I think it had the unintentional consequence of giving it some validation. So if I was the prosecution, I would shorten my presentation, I would cut it in half. I also think what it did is it blunted the impact of some of the good evidence. You can't have a good critical witness testify on a Monday and then go through 2 or 3 days of witness testimony that had to have the jurors, scratching their heads about the relevance or significance of it. So I think less is more as far as the prosecution is concerned.
Wayne, I want to ask you about the prosecution as well. What would you do different? Is there anything you would do differently in opening statements that you would own, perhaps, that the prosecution didn't own until the closing arguments?
Well, I think the prosecution is going to have a little different approach here. At minimum, I suspect we're going to have witnesses who are better prepared. Some of these witnesses came off as if they were not appropriately prepared for the prosecution and certainly not prepared for the degree to which they are going to be crossed. Many of the witnesses were crossed vigorously by the defense. My sense is that there will not be a radical change in the opening statement. The opening statement, again, is going to have to lay out what the basic elements were here and what the prosecution believes occurred. They may cut to the chase a little more quickly, but I think the biggest change is we're going to see witnesses who are now more familiar with having testified, who have testified before and understand the vigor with which the cross is going to come, and who will be better prepared.
Robert, do you think there's any chance that they change how they handle Michael Proctor? Do they call him at all? Do they address the issues that they had to deal with, not only in his direct and cross-examination, but in the way that the defense characterized in their closing argument what happened in this case?
Well, I think you have to call him, right? He's the chief investigator, but I think they need to do a better job of protecting him. Look, you can get out the problems with the cell phone, but then move on from it. He only needs to apologize once, but I think they need to emphasize more. Why did he text what he was texting? What was his state of mind? Something that he knew about Karen really angered him to cause him to do those texts. So I think the defense, in cross-examining him, that aggressively on the text opened the door. So I would have elicited much more of what was Proctor's state of mind. But also highlight the fact that nothing in those texts, well, certainly misogynistic and unprofessional, showed that he believed that there was a cover-up, a conspiracy, or anyone other than Karen Reed responsible. I will just say, retrials are always more difficult on the defendant, because you know what the prosecution case is through discovery. You don't necessarily know what the defense strategy is. So those gotcha moments are going to be muted and blunted on a retrial. They're not going to have the unforced errors with the inverse video. They're not going to have some of the questions that caught witnesses off guard. So it's going to be much more difficult running this thing up again on the defense.
And speaking of people who have to apologize, Joseph, I'm sorry that I said your name again, but I won't get it wrong again. Wayne, let me ask you, the defense. Are they going to do anything different? They had their motion to dismiss. It was denied. They are going to be trying to appeal it. We may see a movement of this trial date, but they know now what these jurors were talking about inside of that jury room, that many of them, and it seemed like mostly the splits that we heard, the majority felt that there was some culpability there.
Well, we don't know that it was the majority. Even the clip that you played earlier suggested there was a 6-6 split on the manslaughter charge. Obviously, you have to pay a lot of attention to the fact that there are crimes here that require intent, and there isn't very little evidence, very little persuasive evidence that she intended to kill him or knew that she had killed him. So I think you're going to get a little more attention to the manslaughter charge, a little more attention around the drinking issues, but it's going to be the same trial for them in many, many respects, although quite frankly, there might be less of a gotcha factor with Michael Proctor, but he's even in a worse position as a witness than he was previously, having been dismissed as a result of his activities in this case.
Joseph, I only have 10 seconds, but could you tell me what you think the outcome of this second trial is going to be?
I think they're going to charge her with just the manslaughter charge, and I think if they do it the right way, ultimately a jury's going to convict her of motor vehicular homicide by OUI. I think the evidence is overwhelming on that charge, the second charge.
It's a case that has divided a community. Really, all the viewers who have been watching it seem to be on other sides, and questions continue to linger, so we are going to continue to dig into this case. Joseph Kowsky Jr. and Wayne Dennison, thank you for weighing in on this case for us. I'm Julia Jenaé in for Vinnie Politan. We here at Vinnie Politan Investigates are going to keep digging for the answers as the investigation continues.